students, welcome to MOOC on Human Rights in India. In the last module, we saw how a number of matters came before the Supreme Court and other high courts regarding environmental issues. In this module, we will see what principles and what doctrines have been used by the higher judiciary in the process of public interest litigation. Dear students, welcome to MOOC on Human Rights in India. In this module, we will take up the second aspect of the PIL and environment. In the last module, we saw how a number of matters came before the Supreme Court and other high courts regarding environmental issues. We will see in this module what kind of principles, what kind of doctrines have been used by the higher judiciary. You are all aware of the public interest litigation, how the higher judiciary has used judicial innovation, judicial creativity to craft new strategies, to come out with new remedies through this public interest litigation. In particular, we will see the polluter pays principles, precautionary principles, and the principle of absolute liability and the sustainability development and the public trust doctrine in this particular module. Let us take up each of these principles and doctrines for greater examination. First, let us see the precautionary principles. Basically, it involves an examination whether a particular development process is environmentally sustainable or not. Any substance or activity which is posing a threat to the environment should be prevented from damaging it. And here the onus is on the actor, on the developer and the industrialist to show that his or her actions are environmentally sound. Now, let me give you few examples of cases which went before the Supreme Court. For instance, in Vellore Citizens Forum versus Union of India, which is otherwise known as Tamil Nadu Tanneries case, the operation of tanneries polluted the groundwater, made hundreds of acres of land in 5 districts uncultivable, and in this case, Justice Kuldeep Singh, who is known as a green judge, held that polluter pays principle, precautionary principle, and sustainable development are all part of a environmental law. And so here, in the process of interpreting the law, the Supreme Court said, as long as certain principles of customary international environmental law, if they are not in conflict with the municipal law, can be relied upon, and thus the court read the precautionary principle or the polluter pays principle or the sustainable development principle into the Indian law. And here the court clearly mentioned that these tanneries should not release water without proper water treatment plants. Let us now take up MC Mehta versus Union of India. As you know, the MC Mehta, one of the finest environmental activists, and he filed a number of cases. In one case, which is otherwise known as Taj Mahal case, certain coke and coal-based plants in the Taj trapezium area were causing serious atmospheric pollution, and they were endangering world-renowned and as a protected monument, which is regarded as a part of a World Heritage. Now, in this case, the court, having regard to the precautionary principle, having regard to the polluter pays principle, asked for a relocation of these coal and coke based industries, and the court also said that this particular precautionary principle and polluter pays principle are part of the environmental law of India. Now let's come to the one more case filed by MC Mehta, which is known as MC Mehta 2 versus Union of India, which is also known as Ganga river water case. Here the court, having regard to the precautionary principle, directed all the municipalities on the banks of the Ganga river to ensure that there is no effluents, no untreated effluents are released into the river Ganga. In one case filed by MC Mehta involving vehicular pollution in the metropolis of Delhi, in the capital city of Delhi, the Supreme Court ordered that vehicles which are more than 20 years old should not be allowed to be operated in the capital city, in the interests of preventing damage to the environment. There have been many other cases which went to the Supreme Court, and using this precautionary principle, the court gave directions about noise pollution in the process of construction of multi-storied buildings in Chennai, or the environmental damage caused by shrimp culture or aquaculture in the coastal zones. Having considered the precautionary principles, let us turn our attention to the second principle relating to polluter pays. In other words, in the international environment law, there is a principle which lays down that the polluter has the liability to pay for the damage caused to the environment. In the last module, we saw the Bijdi village case, where a non-governmental organization, namely the Indian Council for Enviro Legal Action, filed a case against the Union of India about the operation of a firm near Udaipur, which is involved in hazardous chemicals, and it was damaging the groundwater, it was damaging the soil, and in this case again the Supreme Court endorsed the polluter pays principle and held that the absolute liability of the firm that is operating the particular concern and which is polluting the environment must compensate all individuals who have been affected by the damage to the environment. And the court also held that the absolute liability of that firm also extends to the remediation of the damaged environment. In other words, the court must compensate the individuals affected, but also ensure that the environment must be restored to the previous position which was there before its operation. Here it's very important to note that there are two aspects. One is prevention of damage to the environment, and second is the remediation of damage to the environment. There are two aspects involved here. One is efforts to prevent damage to environment, and second is remediation of damaged environment. The court held that the costs should not be passed on to the government, and it's not the government that has to take these efforts, and which the court said will become a liability of the taxpayer, and the court in fact held that the firm that is damaging the natural environment is liable or is absolutely liable for payment of the costs to the villagers who have been affected by its operations, and also for restoration. Remediation of environment has also been held to be a part of sustainable development. There is one more case under the polluter pays principle, which was filed by MC Mehta. Here it's known as, of course, the Calcutta Tanneries case, and the court ordered for the relocation of the polluting industries and also asked them to pay 25% of the land costs. Let us turn our attention to the third principle of absolute liability. Generally, in tort law, there are two major issues. One is intentional wrongdoing, and second is a negligent wrongdoing. And in the case of Rayland versus Fletcher, certain exceptions were noted. Basically, in fact, for the negligent wrongdoing, there is a strict liability, but the exceptions being act of God or vis major, or plaintiff consent, or act of stranger, or statutory authority. Insofar as matters relating to conservation of environment or protection of environment is concerned, the Supreme Court held that there is an absolute liability of the unit that is damaging the natural environment. In other words, there can be no exceptions whatsoever. If a firm is engaged in a hazardous activities, it has an absolute liability. Now let me illustrate with a case which was taken by MC Mehta against the Shriram Chemicals and Shriram Food and Fertilizers and Union of India, in what is also known as oleum gas leak case. Here there was a firm which was engaged in a patently hazardous chemical processes, and in the release of this toxic oleum gas affected a lot of civilians, and so the court held that the firm had an absolute liability on account of its the hazardous nature of the activities it was engaged in. Now let us turn our attention to the fourth principle of sustainable development. If you look at the Brundtland report, which was commissioned by United Nations, the sustainable development has been defined as that process of development which meets the needs of the current generation without compromising on the ability of future generations to meet their own needs. Here, on the one hand, the principle of economics, on the other hand, the ecology have to be integrated at all levels of decision making. And in a number of cases, the Supreme Court upheld the principle of sustainable development. If you look at the Vellore Citizens Forum versus Union of India, which involved the release of untreated waters by the Tamil Nadu tanneries, the Supreme Court said that the sustainable development is extremely critical for eradicating poverty, for improving the quality of human life, and the court also said that pollution should be commensurate with the carrying capacity of the ecosystem. In a number of other cases, the Supreme Court upheld the principle of sustainable development. In particular, in MC Mehta versus Union of India, Apex Court highlighted the need to strike a balance between the needs of development on the one hand and the demands of the conservation of environment on the other hand. In ND Jayal versus Union of India, the Supreme Court said that right to clean environment and right to development are both a part of the Article 21 dealing with the right to life, and the court also said sustainable development is a means to achieve both the right to development as well as right to life enshrined under the Article 21 of the Constitution. Now let us turn our attention to the fifth principle of the public trust doctrine. What do we understand by the term public trust doctrine? Here there are certain resources like air, river water, or forests or seas. They belong to everyone, regardless of economic capacity, and should be enjoyed by all. And there's one matter which went to the Apex Court, which involved a case between MC Mehta and Kamal Nath. I'll tell you the facts of the case. So there was a span motels which was given some land in a forest in the form of a lease, and they tried to divert the river Bias water, the flow of the river, as it was flooding the motel time and again. So the court came down heavily on them and said it violated the principle of the public trust doctrine, and it cancelled the lease of the forest land to the span motels, and also ordered, after following the due process, a pollution fine of rupees 10 lakhs. Now let me draw your attention to one more case involving MI Builders versus Radhe Shyam Sahu. Here the facts are as follows. There was a historical park in Lucknow called Jandewala Park, and there was a proposal to build an underground shopping complex below that park, and in this case a lot of it was already constructed, but the court took the stand that here is a public trust involved, and as it was a park which was for the benefit of everybody, and the court ordered the Lucknow Nagar Mahapalika to ensure that that as the park is a common resource which have to be enjoyed by all, it rejected the construction of the underground shopping complex below the park. So in a sum or in conclusion, we have seen the precautionary principle, the polluter pays principle, and the sustainable development principle, absolute liability, and the public trust doctrine, and how the Supreme Court, through the process of public interest litigation, through the process of creating a number of innovative and creative processes and strategies, applied in a range of cases and upheld them in this process. Thank you. See you in the next module.